Hi, I'm Charles Hatley with I Now Pronounce You Divorced, and I'm here today with Rebecca Malone and Dan Cuneo. And today we wanted to talk about something that is always very interesting to me. We always get a lot of phone calls and a lot of inquiries from people saying, "Hey, I'm separated. Do I have to leave the house?" Or, "Hey, I'm separated. I can't force my spouse to leave the house. What do I do?" And I always really enjoy talking to people about that because so much of what we perceive to be the right way to handle a divorce is based off what we've seen on television and media. Is that when the parents get divorced, one party packs up the suitcase or goes out for milk and never comes back, and the other party stays in the house with the kids and is somewhat the full time parent. And it's interesting as our society continues to evolve that that party generally used to always be mom would stay and dad would leave, but we're seeing some changes there. So I think that that's very interesting and relegates the need to use party over mom or dad. But as we advise clients, whether or not you leave the house becomes a very very big question, and what can I do to make the other side leave the house becomes a very big question. So I wanted to start off with Dan and kind of get your take on your opinion. Let's start from the person wanting to leave the house. Get your take on the opinion of leaving the house. And if somebody decides to leave the house, what should they do?
Sure. It's a question I get all the time, and especially when I was really litigating and meeting with clients or prospective clients. It's what do I do, right? And so I took all that information and would we I was part of a seminar that we would go across the country and put on kind of the mistakes that people make when they go through a divorce or a separation. And the number one mistake is leaving the house. And we had it as the number one because everybody does it. But then it's like, okay, well,
Mhm.
what do I need to do? How do I not make this mistake? Because it could be beneficial or it could be adversarial or not so beneficial. And it really, I'll say this, I'll open it like this. It depends on the jurisdiction that you're in, right? Because each state is different and it could have implications that you're not aware of. So regardless of where you're at, I strongly encourage and advise you to speak with a licensed attorney in that state who practices within domestic relations family law. I general practitioners are okay, but there's so many nuances in family law. And so I would say in the seminar, you wouldn't go to a GP if you had needed something with your brain or your heart, right? You'd go to a specialist. Well, in a lot of states, you can't say you specialize in a certain area of the law. So you just want to make sure that you go to someone that focuses their primary practice on family law and domestic relations law. So, with that being said, you want to make sure that you're talking openly to your attorney as the reasons why you either want to leave the house or you want your spouse to leave the house. Now, if there's any concern or issue with domestic violence, if you fear for your life or your safety, get out, call the police, file a report, and talk to an attorney. Absent that, you want to be strategic about it because in one state that I'm licensed in, one of the parties has to eventually vacate the residence, right? In North Carolina, you have to be physically separate for a year and a day. That's the magic language there. That's statutory. So in order to be divorced, you have to be out of the house. You can't be in separate bedrooms as you can in other states I'm licensed in. So physically separate for a year and a day. But before you get there, you want to talk to an attorney and make sure that you have a potential separation agreement in place, or at least kind of rules of engagement, I would call it in the seminar that I would conduct. And it's here's what's going to happen that's going to control why we're separated. Because you want to make sure that you're protected. You don't want to give up any rights. A lot of clients will come in and say, my wife left, she abandoned me, or I want to leave, but I don't want to be that to be considered abandonment. And in the states that I'm licensed, an abandonment really is leaving the residence for a period of 6 months or more with zero communication. So vacating the residence doesn't always necessarily mean you're abandoning the spouse or the family. So just know that in advance. But again, talk to a licensed practitioner. So you want to make sure that before you leave, you have your ducks in a row, which is okay. Do I have any concern that my spouse is going to liquidate my bank accounts? Is there any concern that my assets or property is going to be sold or given away? Is there anything that I cherish as far as like a family heirloom or an inheritance or something that just means a lot to me that I may not get back? And it has nothing to do with money. It could just have that sentimental value. And so make sure that those are protected. And then have discussions. If you think you can with your spouse, talk about what it looks like to separate and make sure that you're amicable going through that process. If there's kids involved, definitely don't leave the house until you have a temporary arrangement in place, because once you leave, it's harder to get back in. And I've seen it time and time again where once one spouse leaves, the other spouse will file some type of unnecessary order of protection or protection from abuse, whatever it is in your jurisdiction, just to keep that other spouse away. Or a spouse may file that to remove the other person. So there's so many implications as far as if you want to vacate the premises. But I I say the first step is, once you're at that mindset that one of you has to leave, talk to a licensed attorney in your state where you're going to file.
Yeah, that is so important, right? You talk about putting a plan together. Something as simple as, is there something that is so important to you that you can't get it back, like an irreplaceable family heirloom? I'll give the example. I was doing a divorce, and we'd gone all the way through. We're at the very end of settlement. It was like 1 o'clock in the morning, and the guy said, "Hey, I want my mom's wedding ring back." And it's a very sad story surrounding his mother's wedding ring, and that was his heirloom from his mother. And the other side said, "Oh yeah, I pawned it for $5." And she just said, "I did it because I'm mad at you." And even the officiant over the mediation at that point was like, "Well, I guess we're done for the day. Let's go ahead and get out of here." But as sad as that story is, that is something that with a proper plan, he very easily could have just picked up and put in his pocket, right? And that's why it's so easy to sit down and talk to somebody first. Rebecca, when you're talking to people, let's look at the other side of the coin. What do you tell somebody that says, "I want the other side of out of the house," and they won't leave?
Yeah. So in Virginia, you can be separated and within the same household. So it's not essential for one party to necessarily move out in order to start a separation. Um, Unless there's some kind of physical abuse going on, the court is not likely to remove someone from the marital house. So if there's a protective order, if there's been a domestic violence issue, if there's something like that going on, certainly the court's going to intervene and say, yes, the abuser needs to get out of the house and still contribute to certain household expenses and things along those lines. But absent something like that, the court won't necessarily make somebody leave their home. And part of it is, we don't need to drive these parties into debt before we can properly allocate the assets. So if you're trying to force someone out and now they have to go and pay for rent or a mortgage or whatever and still contribute to the marital house, they're probably going to be falling behind somewhere, right? They're not likely going to be able to pay for all of these expenses. And in Virginia, it takes at least a year usually to work your way through the court system and ultimately get to your divorce. So there's not a lot of bases for removing or getting the court to remove somebody from the house. So again, the best course is to try and reach an agreement. Some of the arguments that I've seen have been, "Oh, well, my name is on the deed. My spouse is not on the deed. I'll just go file an eviction." No, you can't do that. If it's the marital home, then both spouses have the right to be there, absent something like a protective order being put in place. So it doesn't matter whose name is on the title, who bought it, who's been paying the mortgage. The court's going to say, if this is the status quo, both parties are living in the same house in different rooms, that's what we're going to maintain through the separation until we can get to a divorce and figure out what we're doing with the property.
Yeah, I know in Virginia, during the penente lite, the temporary order phase, there is something called exclusive use and possession of the marital home. And that is outside of a protective order. Can you kind of walk us through what is exclusive use and possession of marital home and what would constitute the court ordering that?
Right. So again, if there's been a protective order, if there's been domestic violence, then also your divorce court may say, and we're also giving exclusive use and possession. Certainly, they can kind of just layer it on. It's just another layer of protection. In a scenario where one spouse has already moved out, but maybe they keep coming back into the house and it's at unexpected times, and maybe they're messing with household items or something along those lines, the court may say you don't have any reason to be going in and out of the marital home. You have your home. The other party's staying in the marital home. So we're going to grant exclusive use and possession, which means other spouse, you can't just come in and out as you please. That's not going to be viable. You can sometimes have an award for exclusive use and possession if you haven't quite met the standard for a protective order, but there's something along those lines going on. There's something about the other party's conduct that is leading to an unsafe environment, or there's something problematic about their presence in the home. But it's kind of few and far between that you get an order like that to completely remove someone if you don't also have a protective order or a domestic violence case.
I know I had a case where the spouse was an alcoholic, so they would come home from work at like 5:30 at night, and I don't know how they did this, but they would stay up all night drinking and listening to music, fall asleep at like 4 o'clock in the morning, get back up at 5:30, go to work, come back home, and repeat.
Mm.
And so we were able to get exclusive use and possession based off the extreme annoyance of that and what it was doing for the children. Dan, is there anything like that in the states where you're licensed in?
Sure. If you have children, it definitely adds an additional layer of either oversight or an additional layer of protection that the courts are going to have to take into consideration. So when there's children involved, the courts really want parents to have and encourage frequent, meaningful contacts, kind of the legal buzzwords in a lot of states that I'm licensed in. But if the parents cannot get along, you really don't want to subject the children to that. And in that situation, it's always best, if it's possible, for one party to vacate the premise and have an agreement in place to where each parent knows when they're going to see the child or the children, who's going to pick up, who's going to drop off if they're of that age, but then also how are the marital expenses going to be paid? Because as Rebecca mentioned earlier, if you vacate, you have dual expenses. And can you, as a marital unit or family unit, afford that? And our job, I feel, as practitioners, is to really start flushing out and digging into what does that look like. You may not be happy with your spouse, but if you can tolerate them and stay in separate bedrooms or on different levels, if you have that, or in a basement, and work through this, that's really going to be the most optimal outcome and best for you, because now you're not wasting marital finances on an apartment for rent or whatever the case may be. And you're allowing yourselves to try to work it out, especially if there's kids there. They want to be able to see a mom and dad try to be at least amicable and civil towards one another. But that's not always the case. I mean, that's ideal. And we get, as practitioners, that if you have two people in a house and they've reached that point to where they are acrimonious and there is going to be that adversary or adversarial contact communication, then it's probably best to just diffuse it and separate. But before that happens, you want to make sure that you have that game plan in place. I can't stress enough how important it is before either you vacate or your spouse vacates to have that plan in place, those rules of engagement, because that's just going to cut back on a lot of frustration, a lot of heartache, and it's going to save you time and money at the end of the day. And our job, again, as practitioners, is to look out for the best interests of the client, which is going to be giving you some of those tough decisions to make and guiding you through that process and what that looks like. If we have to litigate, of course we're going to litigate. That's our job, right? We always prepare for litigation. We hope for settlement, but we'll prepare for litigation. But at the same time, preparing for litigation allows facilitation of settlement to really happen. And it allows more fruitful, productive communication and conversation to happen, whether it's between the parties, between the attorneys, between the mediators, or at a court. But we just want to make sure that as we're progressing along, that if one of the parties will vacate the marital residence, that we know what that's going to look like. Because if you don't, then there's just so many implications that could happen, as far as time, being denied time with your kids, denied access to finances, not allowed back in the marital home. And in some states that I'm licensed in, the date of separation is so important, because anything that you acquire after the date of separation could be considered your separate property, right? I mean, there's always those things as far as you're not waiving your right or interest in the marital estate. but the potential increase in equity you could be, or increase in retirement accounts. So there's things that we want to make sure that we're protecting you, that once we establish what that data separation is, you know what the plan is moving forward, but we're also making sure that you're not waiving or giving up any of your rights to property or other assets.
Yeah, and that's so important. When you're going through this process, you need to understand there's a lot going on, right? You're trying to protect your relationship with your children. You're trying to protect your rights and property. You're trying to set a cutoff date saying that, our relationship's over, but for the court making me wait. I've got to protect my future property rights that are going to happen in this time period. And Dan, I kind of want to stick with you here. Is there any mechanism? So I know in Virginia we have two types of divorce, and I'll use the non-Latin phrases. We have full divorce and we have partial divorce. Is there anything like that where you're licensed at a full divorce or partial divorce, and what does that mean?
Sure. So in North Carolina, it's called an absolute divorce. So that just means your
Mm-hmm.
marriage is dissolved. And there's a lot of issues and implications leading up to that, to where, again, you want to make sure you talk to somebody, because if you're wanting any type of support, but you get that divorce, the absolute divorce granted, you're barred from seeking that. So you want to make sure that you're speaking to somebody and taking the necessary steps to prevent that from happening. That doesn't mean when someone files for the absolute divorce that it's granted and then you automatically waive. You have time to respond, but you just don't want that to be waived. But that won't happen until 1 year and 1 day in North Carolina. But in other states that I'm licensed, for example, Missouri and Illinois, it's from the date of the marriage until date of divorce. Everything in between is still considered marital property. Now, you can make an argument in equity, and it's going to be really dependent upon the judge. I've had the same facts and argued them in front of two different judges and two different opinions there. But you want to make sure that once you separate, again, you have that plan in place. But in Missouri and Illinois, you're either married or you're divorced. You can be legally separated for sure, and you can have that while you're going through. And if you can come to terms as far as what you agree upon, then that can be put into the actual divorce decree. But as far as partially divorced or divorced, not in those states. Now, in Missouri, you can file for legal separation, and in Illinois, you can too. And what that means is you're going through the exact same process as you would with a divorce. But at the end of the day, you're essentially saying, judge, court, I want to protect myself, but I'm not sure if this marriage is going to work out. We haven't reached a point where we want to dissolve it, but I just want to make sure that we're doing what we need to do to protect ourselves. Now, the benefit to that really is just only a handful of things. It could be if you truly want to work on the marriage, sure, maybe legal separation is the route to go, but you're still married. So you want to make sure that you put into that agreement that any assets or debt that's acquired would be considered that other person's property or debt, depending upon the situation, of course. But others do it for religious reasons. I've seen that a lot. So that's a pretty big issue on why others would come in and say, we just want to be separated. You could get an annulment. Those are a little bit more challenging and harder because there's only certain grounds for the court to actually annul the marriage. Is basically if it was void or voidable or under some type of criminal circumstances. But absent that, it's really going through the actual divorce process where I'm licensed. Hi, this is Dan Cuneo with I Now Pronounce You Divorced. Thank you for taking time to listen to this week's podcast. Please join us next week for part 2.
Thank you for tuning into our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.